Hello. Like and subscribe naman para ganahan sad ta. Test for determining the relevancy of evidence. 1. Because of the definition of relevant evidence under Sec. 4 of Rule 128, it is obvious that relevance is a matter of relationship between the evidence and the fact in issue. The determination of relevance is, thus, a matter of inference and not of law. The test is, therefore, one of logic, common sense, and experience. 2. The existence of the relationship between the fact in issue and the offered evidence is one that is perceived only by the mind without reference to a statute or rule. It is, therefore, a matter of reasoning. It is a matter of reasoning because relevance is a matter of logic. The matter of relevance is one that is addressed to the discretion of the court. The case of People v. Galeno, 291 SCRA 761, is enlightening. There is no precise and universal test of relevancy provided by law. However, the determination of whether particular evidence is relevant rests largely at the discretion of the court, which must be exercised according to the teachings of logic and everyday experience. Collateral matters. 1. A matter is collateral when it is on a parallel or diverging line, merely additional or auxiliary. Black's Law Dictionary, 5th ed., p. 237. This term connotes an absence of a direct connection between the evidence and the matter in dispute. 2. For instance, the motive of a person and, in some instances, his reputation are matters that may be considered collateral to the subject of a controversy. A very strong motive to kill the victim does not ipso facto make motive relevant to the issue of guilt or innocence because the person with absolutely no motive to kill could be the culprit. Evidence of the bad reputation of the accused for being troublesome and aggressive does not make the evidence admissible to prove his guilt. After all, the culprit could have been the person with the most endearing reputation. When collateral matters are allowed. 1. As a rule, evidence on a collateral matter is not allowed. Sec. 4 Rule 128, Rules of Court. It is not allowed because it does not have direct relevance to the issue of the case. This rule, however, is not an absolute rule. There exists an occasion when evidence on a collateral matter may be allowed. 2. Under the rules of court, a collateral matter may be admitted if it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Sec. 4 Rule 128, Rules of Court. In other words, while the collateral evidence may not bear directly on the issue, it will be admitted if it has the tendency to induce belief as to the probability or improbability of the issues of the case as when it would have the effect of corroborating or supplementing facts previously established by direct evidence. Illustration: although evidence of character is generally inadmissible, Sec. 51 Rule 130, Rules of Court, the accused may prove his good moral character which is pertinent to the moral trait involved in the offense charged. Sec. 51101111 Rule 130, Rules of Court. In civil cases, evidence of the moral character of a party is admissible when pertinent to the issue of character involved in the case. Sec. 511 BJ, Rule 130, Rules of Court. Also, evidence of the good character of a witness is admissible if his character has been previously impeached. Sec. 14 Rule 132, Rules of Court. Relevance of evidence on the credibility of a witness. 1. Evidence on the credibility of a witness, or the lack of it, is always relevant. In every proceeding, the credibility of the witness is always an issue because it has the inherent tendency to prove or disprove the truthfulness of his assertion and, consequently, the probative value of the proffered evidence. Every type of evidence sought to be admitted, whether it be an object or document, requires the testimony of a witness who shall identify, testify, and affirm or deny the authenticity of the evidence. Thus, when the credibility of the sponsoring witness is found wanting, Sec. 11 of Rule 132 authorizes his impeachment by contradictory evidence, by evidence that, in the past, he has made statements inconsistent with his present testimony, or by evidence that his general reputation for truth, honesty or integrity is bad. 2. In the assessment of the testimonies of witnesses, the court is guided by the rule that for evidence to be believed, it must not only proceed from the mouth of a credible witness, but must also be credible in itself, such as the common experience of mankind can approve as probable under the circumstances. There is no test of the truth of human testimony except its conformity to our knowledge, observation, and experience. Whatever is repugnant to these belongs to the miraculous, and is outside of judicial cognizance. People v. Kalimpang, 454 SCRA 719, Ubalis v. People, 570 SCRA 251-3. The importance of the credibility of a witness in a judicial proceeding is highlighted by rules which allow the adverse party to test such credibility through a process called cross-examination. Hence, under Sect. 6 of Rule 132, a witness may be cross-examined by the adverse party not only on matters taken up in the direct examination. The broad spectrum of the questions allowable in a cross-examination of a witness also includes those matters connected with those testified to in the direct examination. It includes questions designed to grant the cross-examiner sufficient fullness and freedom to test the accuracy and truthfulness of the witness, his freedom from interest or bias, or the reverse. It likewise covers inquiries into matters that elicit all important facts bearing upon the issue. Since Sect. 6 of Rule 132 affirms the legitimacy of inquiries into the credibility and biases of a witness, any objection to a question that intends to demonstrate the lack or absence of credibility of the witness on the ground that it is irrelevant or merely collateral does not deserve to be sustained. 4. There are, however, instances provided in the rules where the questions of the cross-examiner are circumscribed by the matters taken up in the direct examination. Thus, questions outside the subject matter of the direct examination are not allowed. An accused may testify as a witness on his own behalf but subject to cross-examination on matters covered by direct examination. Sec. Limited, Rule 115, Rules of Court. B. A hostile witness may be impeached and cross-examined by the adverse party, but such cross-examination must only be on the subject matter of his examination in chief. Sec. 12 Rule 132, Rules of Court. Competent evidence, Bar 2004. 1. Competent evidence is one that is not excluded by law or rules in a particular case. Moran, Comments on the Rules of Court, Volume 5, 1980, citing Porter v. Valentine, 18 Misc. Rep. 213, 41 NYS 507. The admissibility of the evidence depends on its relevance and competence. XXX Tating v. Marcella, 519 SCRA 79, italics supplied. 2. If the test of relevance is logic and common sense, the test of competence is the law or rules. If the law or a particular rule excludes the evidence, it is incompetent. Competence is primarily, therefore, a matter of law or rule. The question as to competence is the evidence allowed by the law or rules? If it is allowed, the evidence is competent. If it is not allowed, it is incompetent. Imagine and assume, for the sake of illustration, that a rule of evidence has just been adopted mandating that only documentary evidence to which have been attached a yellow ribbon on the bottom right corner may be marked and admit TED in evidence. If the adverse counsel presents for identification and marking a document to which had been attached a red ribbon, the document is to be excluded because it is not competent. It is incompetent because the rule says so regardless of its demonstrable logical relation to the fact in issue. 3. Competence, in relation to evidence in general, refers to the eligibility of an evidence to be received as such. However, when applied to a witness, the term competent refers to the qualifications of the witness. In other words, competence refers to his eligibility to take the stand and testify. It is in this context that the term is normally associated with. Thus, a trial objection employing the ground incompetent is usually used in relation to the ineligibility of a witness to testify because of the presence of a disability that renders him unfit to sit on the stand. If evidence offered is objected to on the ground that it is incompetent, such objection is not an accepted form of objection because it is a general objection. The objection should specify the ground for its incompetence, such as leading, hearsay or parole. Although evidence is incompetent if excluded by law or the rules, evidence is not objected to on the ground that it is incompetent. It is so general a term and cannot be appreciated in court. Courts neither need nor appreciate generalities. General objections are viewed with disfavor because specific objections are required under Sec. 36, Rule 132 of the Rules of Court. Thus, for purposes of trial objections, evidence is never incompetent. It is people who are. It is sloppy usage to object to a testimony or document as incompetent. Such term more appropriately describes a witness who, under evidentiary rules, does not possess the qualifications of a witness or suffers from a disqualification to be one. Competence of electronic evidence. Electronic evidence is competent evidence and is admissible if it complies with the rules on admissibility prescribed by the rules of court and related laws, and is authenticated in the manner prescribed by the rules on electronic evidence, Sec. 2 Rule 3, Rules on Electronic Evidence. Admissibility and weight probative value of the evidence. 1. Admissibility of evidence refers to the question of whether or not the evidence is to be considered at all. On the other hand, the probative value of the evidence refers to the question of whether or not JE proves an issue. PNOC Shipping and Transport Corporation v. Court of Appeals, 297 SCRA 402 as cited in Atienza v. Board of Medicine, 642 SCRA 523, 529, February 9, 2011. Thus, a particular item of evidence may be admissible, but its evidentiary weight depends on judicial evaluation within the guidelines provided by the Rules on Evidence. Heirs of Lord C. Sabanpan v. Cormaposa, 408 SCRA 692. Admissibility is one thing, weight is another. To admit evidence and not to believe it are not incompatible with each other. Calamba Steel Center, Inc. v. Commissioner of Internal Revenue, 457 SCRA 482. 2. Stated in another way, the admissibility of evidence should not be equated with the weight of the evidence. The admissibility of the evidence depends on its relevance and competence, while the weight of evidence pertains to its tendency to convince and persuade. A particular item of evidence may be admissible, but its evidentiary weight depends on judicial evaluation with the guidelines provided by the Rules on Evidence. Tating v. Marcella, 519 SCRA 79. Multiple admissibility, Bar 1984, 1991, 2005. 1. There are times when a proffered evidence is admissible for thus, depending upon the circumstances, the declaration of a dying person may be admissible for several purposes. It may be offered as a dying declaration, Sec. 37 Rule 130, Rules of Court, part of the res gestae, Sec. 42 Rule 130, Rules of Court, or declaration against interest, Sec. 38 Rule 130, Rules of Court. The statement by a bus driver immediately after the collision, that he dozed off in the wheel while driving, may be admissible as an admission under Sec. 26 of Rule 130 or as part of the res gestae pursuant to Sec. 42 of Rule 130. The Court, in People v. Salafranca, 666 SCRA 501, 511, February 22, 2012, illustrates the principle of multiple admissibility, thus. It appears from the foregoing testimony that Bolanon had gone to the residence of Astano, his uncle, to seek help right after being stabbed by Salafranca, that Estafio had hurriedly dressed up to bring his nephew to the Philippine General Hospital by taxicab, that on the way to the hospital, Estafio had asked Bolanon who had stabbed him, and the latter had told Astano that his ASSNJLNNL had been Salafranca, that at the time of the utterance Bolanon had seemed to be having a hard time breathing, causing Estafio to advise him not to TALLC anymore, and that about 10 minutes after his admission at the emergency ward of the hospital, Bolanon had expired and had been pronounced dead. Such circumstances qualified the utterance of Bolanon as both a dying declaration and as part of the res gestae, considering that the court recognized that the statement of the victim an hour before his death and right after the hacking incident bore all the earmarks either of a dying declaration or part of the reg gestae, either of which was an exception to the hearsay rule. 2. Sometimes, evidence is inadmissible for one purpose but admissible for another or vice versa. For instance, evidence of a person's bad general reputation for truth, honesty, or integrity is objectionable if offered to prove that he committed the crime charged, but it may be admissible to impeach the credibility of a witness under the authority of Sec. 11 of Rule 132, 3. Evidence may also be admissible against one party but not against another. An extrajudicial statement of a Rob Berry suspect is not admissible against his co-accused under the res inter alios acta rule but may be admissible against the declarant himself as an admission pursuant to Sec. 26 of Rule 130. Thank you.